flip it over. There you go. Okay. Yeah. Yeah.
Yeah.
Just let him know that.
You know, when you're
Ready, sir.
Madera County Assessment Appeals Board meeting is called to order. Today is 9 a.m. and today is June 3rd, 2021. We'll start with the invocation and pledge of allegiance. Please all rise. This time is allowed for any public member who would like to speak on any topic that is not on the agenda. Is there anybody present here who would like to speak on any other matter that is not on the agenda? I don't see anybody. Okay, so we'll proceed. Consent calendar. You have we need to approve the minutes of the last meeting. Is there any comment on the
Chairman.
agenda?
You'll approve the entire consent calendar, which will include the minutes as well.
Yes, ma'am. Okay. We have a motion.
I move that we approve the consent calendar.
I second.
Okay, we have a motion, we have a second. All in favor say aye. Aye. Motion passes. Okay, at this time, we'll like to, if we have a few hearings here, and are the people from Walapshan, Suzanne, present here? Item 5A.
Brian Glover, Deputy Assessor Real Property for the
Yes, sir.
Madera County Assessor's Office. I talked with Mr. Golashan yesterday, and he did indicate he was going to be here.
Okay.
He is coming from the Bay Area.
Okay, I was just checking at this
So
time. Okay.
If perhaps
How-
we could shuffle him to the
Thank you.
back.
Thank you, we'll see. How about ampersand Tauchila, representative from that company available? Okay, sir. Thank you, sir. Be seated. Okay. All right, at this time, we'll do the, we have to do the swearing in, but the other part is not here. Sarah, how we want to do it? Hold it until we can skip to the next item, which is 6A, and then we'll come back to the hearings.
I think we need to approve these.
The other side, yeah, okay, all right, we can go with it. Thank you.
Sarah, do we need to approve these referrals?
That's on the consent calendar.
Okay,
That's
do
part
we
of
need
the
to cover
consent
4B
calendar.
and 4C, or is it covered under the consent calendar?
Yes.
Right, okay, thank you. So we move on to item 6A, 6987, which is consideration of approval of stipulation of assessed value for Triangle Rock Products Incorporated for a total assessed value of $5,434. Assessor's office, what would you like to say on that?
Good morning, board members. This is Tran Cooper representing the Assessor's Office, the Deputy Assessors for the Business and Personal Property Division. After the applicant have submitted information for review, it was determined that a lower depreciation factor is more reasonable for the subject property for the lien date of 2000.
So is this the final value?
That's correct, sir.
And the applicant agrees to that?
Yes, the applicant has signed a stipulation also.
Okay. Are there any questions, the members?
No. I just move that we approve the consideration of the stipulated value of the Triangle Rock Project, Inc.
Second that.
Okay, we have a motion, then we have a second. So, all those in favor say aye.
Aye.
Aye. It's approved. All right, so let's come back to, do we want to wait on item 5A and go to the 5D? Should we do that? Okay, for that, we can do the swearing in for the parties that are going to be presenting this item. Sarah, would you please do that?
Does everyone giving testimony today solemnly swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God? Please make sure you sign the oath statement. Yours is at the podium.
Oh, no.
No, on this side. Oh, boy.
We just bringing us the copies.
I guess. Are you representing Gulf Shan Company? What are these?
They are the Assessor's Office
Okay,
personnel.
Okay, I'm sorry.
Oh, I thought
All
so
right.
too. I'm like,
Okay.
oh, they're here.
Can you try to contact them so we know, should we give
Yeah,
them allow them
I'll
time?
step out and try and give him a
Okay,
call.
please, thank you. Okay, while we're getting ready, let me read out the procedure for the hearing. Those who are presenting any of these items today, pay special attention. Assessment Appeal Board meetings are conducted under the direction of the chairperson. Each item scheduled for public hearing at an Assessment Appeal Board meeting will be announced by the chairperson. The hearing will be conducted as follows.
Thank you.
Yes, sir. So you pay attention since you're going to be presenting. The clerk shall swear in all witnesses at the start of the hearing and provide an oath for all witnesses giving testimony to sign. Requests for written findings of fact must be submitted and fee paid before the closure of the hearing, or findings of fact shall be deemed waived. All testimony presented by the applicant or the applicant's agent must be conducted from the podium. When beginning to speak, first identify yourself. This is required for the public record. Since all meetings are recorded, please speak clearly and use the microphone provided. All remarks must be addressed to the AAB. Conversation or debate between an applicant, agent at the podium and a member of the audience or staff is not permitted. Both parties shall have the option to present an opening statement not to exceed 5 minutes each. The party with the burden of proof shall present its opening statement first. Following the opening statements, the party with the burden of proof shall call its witnesses and introduce evidence. The opposing party shall present its witnesses and evidence in the same manner. For appeals assessed at less than $30 million per appeal, each side shall have a maximum of 3 hours to present its witnesses and evidence, including rebuttal testimony, opening statement, and closing argument. For complex appeals, the maximum time limit is 4 hours. Only relevant evidence is admissible, and when a witness is excused, he or she may be recalled only once for rebuttal of the opposing party's evidence. Applicants' exhibits shall be numbered 1, 2, and so on, and the assessor's exhibits to be lettered A, B, and so on, prior to submission. All exhibit pages shall be numbered in numerical order. The board shall not recognize objections on the grounds of hearsay, best or secondary evidence, opinion, calling for speculation, assuming facts not in evidence, calling for narrative answers, and authentication. All parties will conduct themselves with courtesy, dignity, and respect. Failure to timely object to evidence introduced shall be a waiver of the objection. The chairperson will make the final determination as to admissibility of evidence. After both sides have finished calling witnesses and presenting evidence, each may present rebuttal. Upon conclusion of rebuttal, each party may provide closing arguments. Closing arguments shall not exceed 10 minutes. The party with the burden of proof may split its 10 minutes to open and close the period of closing argument. The board may announce its decision at the conclusion of the hearing or take the matter under submission to deliberate in closed session. Notice of decision of value will be provided to the applicant, agent, and assessor's office in writing by the clerk upon determination. Thank you for listening. And now, if you are ready, sir, you can state your name and your county of residence.
All right, if I remove my mask?
Sure.
Okay.
Since you, I think the burden of proof is on the applicant in this case, right?
I'm sorry, what was the question?
The burden of proof is on the applicant?
Actually, it's Tran Cooper. The burden of proof lies with the assessor because it's an escape assessment. So
Okay,
I would go present my case first.
yes, you are allowed to do that. I'm sorry, sir. So let me do a little correction here.
No problem.
Okay. Assessor's office first.
Ms. Anderson, have you passed out the presentation?
Yes.
Okay, I'm gonna have my opening statement first.
Yes, of course.
You going to do it from the podium or from?
Oh, you
Okay.
could stay there if you like.
All right, thank you.
You can have a seat, that's no problem, either way.
My name is Tran Cooper. I'm the Madera County Deputy Assessor for the Business and Personal Property Division. I have over 22 years of experience working in the assessor's office. I earned my advanced appraiser certificate for property tax purposes in November 2002. Ampersand Chowchilla Biomass LLC went through a change in ownership that took place in December of 2010. However, through its annual required power plant property statement filed for the tax year 2011, this change was not reported by the Ampersand and the assessor's office, was not reported by Ampersand to the assessor's office or the Board of Equalization via Form BOE 100B. In July 2020, 10 years after the purchase, the assessor's office was informed of the change of ownership when a copy of the legal entity ownership program Form BOE 100B was attached to the assessment appeal applications. When there is a change in ownership, the fixture base year needs to be established. The issues raised by the applicant is that the purchase price of $467,934 should be used as a starting point or base year value for assessment purposes. The assessor will prove with information available to his office that the started purchase price does not meet the full cash value or fair market value in accordance with the Revenue and Taxation Code Sections 110. Therefore, the applicant's stated purchase price cannot and will not be the basics for establishing the base year value. Thank you.
Any questions for assessors?
What's the purchase price again?
Stated with the application was $467,934.
And that was in 2010?
The transfer took place in December of 2010.
And you said they didn't report it until 2020?
Until we were informed in July of 2020. Yes, that was 10 years after.
Okay, what kind of instrument is used to inform you of the change of ownership?
Oh,
Is there
could
a filing required? Or what kind of documentation?
could I
is
ask a
required?
question first? I'm wondering if the applicants would like to make an opening statement first
Yes,
before
thank
I
you.
do my presentation.
Thank you. I was trying to clarify just what you said.
Yeah, well, I would answer that with my
Sure.
presentation. I was just wondering.
You can
if-
hold answer, that's
Yes.
fine, that's okay. Okay, sir. The applicant may do the opening statement for 5 minutes.
Good morning. My name is Stan Blythe. I'm a partner with the law firm Lang, Rickard and Patch in Fresno, and I represent the appellant, Ampersand Chowchilla Biomass. I'm here today not challenging the determination that there was a change of control that wasn't reported. There certainly was, as there was a purchase of 100% of the membership interest of the former ownership, which is deemed a change of ownership under California law. What I'm here today is to challenge the methodology used in determining the value of the property. When the assessor applies an improper methodology for determining valuation that's not in accordance with applicable statute and regulations, there is no presumption of the correctness of the assessment. And given that we have an escape assessment here, there is no presumption in that regard also. First, I'd like to say that the assessor's reliance on the cost approach is flawed in that if you look at Rules 6 and 8 of the State Board of Equalization, the methodology to be used in valuing property is essentially the use of all three methods to the extent they're applicable. The the cost approach, the income approach, and the market data approach. Those three are to be used to the extent they're applicable. And then in the end, they're weighed and you come to a conclusion of value considering all three approaches. The cost approach is never supposed to be used in isolation. And here is particularly problematic because the assessor's reliance on the cost approach failed to consider something that's key in this case. It's the principle of, and I'll talk more about it later, external obsolescence. There's different types of depreciation you consider when you do evaluation based on the cost approach. There's physical deterioration, functional deterioration, and external obsolescence. The external obsolescence in this case arises from the fact that the biomass facility has essentially been knocked out of the marketplace by the cheap abundance of solar power and the growing abundance and the dramatically dropping prices of solar power in California. Because of these market factors, the biomass plant essentially runs at a continuing loss each year. I'll discuss more later the way their agreement for income, and the income approach should have been one of the factors that the assessor looked at when she did this evaluation of the property. Because of the way the biomass power agreement is structured between Ampersand and PG&E, the prices are capped until 2023, and then they're only allowed to charge 60% of the inflationary growth in terms of price increases. So their income will constantly be outpaced by inflation, which will lead to deterioration in income. That's why the income approach should have been one of the factors here, not strictly a cost approach. And again, that the concept of external obsolescence, while it factors in the income approach, is also another method of depreciation that should have been considered and applied by the assessor's office. What the assessor's office has done is simply age life examination. The property has this amount of useful life, it's depreciated over this many years, subtract that, take that, monetize that depreciation, subtract it from the historical cost, and that comes out to their assessed value. That's an incorrect approach in this case. Because, again, the assessor didn't follow the dictates of Rules 6 and 8 of the Board of Equalization, these assessments should not be given any credence, and the enrolled value prior to the escape assessments remain in place. Another issue, just quickly, and I'll talk about it more later, is the issue of historical cost. What is historical cost here? Is it the historical book cost on the records at the time the facility was purchased by Ampersand, or is it the purchase price that Ampersand paid? You'll see in Exhibit 1 in the binder I provided that an appraisal of the facility was done in 2008 in anticipation of our client's purchase of the facility, and they valued the facility at $725,000. And in fact, they paid significantly less than that for the facility. That here, the acquisition cost should be deemed a historical cost because there is authority supporting that, and that's a fair approach, not the historical $17 million valuation that was originally, I believe, carried on the books and records. Thank you.
Thank you. Thank you. Okay. Now, assessor's office, what would you like to say in response? Actually, well, my original question was to you, what is the documentation required to report the transfer of ownership?
May I remove my mask?
Yes, yes,
Okay,
yes.
it's fogging up, I can't see.
Yes.
Okay, so to answer your question, When there's a change of ownership, it needs to be reported to the assessor's office. In the case of legal entities such as this subject property, a form from BOE's number 110 need to be submitted with the state board within 90 days of the transfer.
Okay, thank
It
you.
has not been submitted for 10 years. That's my answer.
Thank you. Okay, so go ahead with your opening statement. You have 5 minutes.
Well, before I make my presentation, I would like to address the issues
No, I'm
at
sorry.
hand.
You already made your opening statement.
Yes,
Sorry.
I did.
Okay, sorry.
It's okay.
So now you present your, go ahead.
Right.
Yes, sorry.
So, Mr. Blythe just bring up an issues that was not part of the application. On the applications, the issues at hand seems to be that we did not use the right cost for valuation purposes. It has not mentioned anything about methodologies other than the cost approach. And I will present it to you. Please give me a minute, I'll put up on the screen. Okay, the presentation package in front of you is also projected on the screen there and also on
Okay.
your screens. So let me go to, as would be Exhibit A, page 18. As you can see right here, this is the letter attached to the application written by Ms. Mandy, the then attorney for the applicant. It say, by way of background, the purchase price ampersand pay to acquire the property in 2010 was $467,934. However, it has become clear the base year value established by the predecessor's acquisition cost improperly endured a change in ownership and has sustained in years since. The purchase price is the appropriate metric in determining the full cash value and should be indexed as the base year value. It seems to me infer that the cost value is being disputed. There's no other issues being raised. They indicated that the purchase price should be used as the base year. Mr. Blythe has just indicated it seemed like they have not followed through with their issues on the application. I just would like for that to be noted. For my presentation, I'm gonna read in my presentation first, and I'm gonna go over the exhibits with you and point out to you different elements of the presentation. My presentation is gonna take about approximately 8 minutes, so bear with me.
That's okay. Go ahead.
Ampersand Chowchilla Biomass LLC will be referred to as Ampersand hereafter. Ampersand is located at 16457 Avenue 24.5 in Chowchilla, California. The Chowchilla facility is an open-loop biomass facility with a capacity of 12.5 megawatts. It generates electricity by using various types of organic waste as fuel. The plant burns agricultural byproducts such as pruning waste and orchard removals and construction debris such as urban wood chips and to produce electricity. As part of the 2019 appeal, I also reviewed prior years' reporting for accuracy and consistency. Various documents and financial information was provided by the Ampersand Certified Public Accountant, or CPA. As a result, escape assessment was processed for tax year 2016 and 2017, which the applicant appealed timely and the subject of today's hearing. The reason raised for the appeals by the applicant is that the assessor's office failed to establish a base year value due to a change in ownership. The change in ownership took place when AMC California LLC acquired interest of Ampersand Chowchilla Biomass Fund 1 LLC, also known as Cal Bio, as referred in the United States court case. It will come clear to you when I will show you the history of ownership. On December 28, 2010. Although this change took place 10 years earlier, the assessors was informed when his office received a copy of the legal entity ownership program file attached to the appeal application. Pursuant to Revenue and Taxation Code Section 64, a change in ownership occurred. For this reason, a fixture base year value needs to be established for Revenue and Taxation Code Sections 51. And to define full cash value, Revenue and Taxation Code Section 110 defines, in part, full cash value or fair market value means the amount of cash or its equivalent that the property would bring if exposed for sale in the open market under conditions in which neither buyer nor seller could take advantage of the exigencies of the other, and both the buyer and seller have knowledge of all the uses and purposes for which the property is adapted and for which it's capable of being used. Purchase price, as used in this section, means the total considerations provided by the purchaser or on the purchaser's behalf. Value in money, whether paid in money or otherwise, which technically means if they assume a loan, that would, even though they didn't pay in cash, it would be considered as a cash equivalent. Although some of the information requested pursuant to Revenue and Taxation Code, Section 441, subsection D was provided, the details surrounding the purchase was not provided, nor is it clear what the documents submitted. An appraisal for this transfer was not provided either. Therefore, I had to rely on my research from other sources. In my research, I found a published federal court case involving the applicants and another related company against the U.S. government. The title of the court case, quote, in the United States Court of Federal Claim, unquote, and that would be Exhibit B, and I will go over those with you. In this court case, I learned that in preparation to apply for the American Recovery and Reinvestment Act, Section 1603 grant, Aikida Capital, the managing company of AMC, quote, retained Nova Radek and Company LLC, a public accounting firm, to act as independent auditor and certify Global Ampersand Section 1603 application, unquote. Mr. Nathaniel Ng, a California licensed CPA, and the Nova Radek manager responsible for the audits agree that the sales price listed by Cal Bio in its 2010 tax return of $74.5 million was the correct acquisition price. In addition, Nova Radek determined that the Chowchilla plant had an eligible cost basic of $40,943,280. After the purchase in 2010, Akita Onshore made improvement to the plant that cost $7.56 million in calendar year 2011. This amount was never reported to the Madera County Assessor through its annual property statement filing. The improvement of $7.56 million would have been added to the base year value. The escape assessment was based on Ampersand's reported cost provided by a California accounting firm hired by the applicant. Value derived from the reported costs are lower than the base year value. Therefore, they are enrolled as directed by Revenue and Taxation Code, Section 51. It should also be noted that the plant located about 25 miles away in Merced County has similar enrolled values for the same tax years.
What's the reason for your rejection?
When rebuttal or having any comments, please make sure that you approach the podium so we can get it on record. Thank you.
Objection to her reference to the Merced assessment. Ms. Cooper did not perform that valuation. It's a different facility with a different historical cost basis and is irrelevant to the matter before this board today, the escape assessments.
Okay, Ms. Cooper, okay, hold on there. Where did you get that information from?
From the last 2019 appeal, that was some of the information that I gathered for that hearing. I just want to make a comment that AMC owns Merced plant as well as of this transfer. And I will show you from a chart, but just that to be noted that also owned by AMC.
His objection is that you didn't perform that.
Oh, that's fine. I just want to make noted that it's part of their plans. I mean, they own two plants, one in Madera and one in Merced County.
Okay, so I guess then
But listen, we have a council there. Ask our council. His
Yes.
opinion.
I would say if it's not a big deal, she has made the point and the objection is valid, could sustain that.
I'm only making the objections to not waive it, so it's fine if you want to determine it later.
It's okay. Thank you. Thank you. Okay, go ahead, Ms. Cooper.
I only have one more paragraph and that's it.
Okay, that's fine. Take your time.
Ampersand Chowchilla Biomass LLC and Merced Power LLC are wholly owned subsidiary of Global Ampersand LLC, an entity wholly owned by ACM California LLC, which in turn is wholly owned by Arcata Environmental Fund LP, or also referred to as Arcata Onshore. Arcata Capital Management control Arcata's onshore, and that's based, these historical ownership information is based on the U.S. court case federal claims. And at this time, I would like to go over the exhibit with you. Okay. This is the presentation, the statistical of the subject property, the years affected, 2016 and 2017. The base year for the 2000 change in ownership is at issue based on their application. I recommend that the board uphold the enrolled value as shown here For 2016, the total of 12,943,750. For 2017-18, the total value of 12,960,850. If you could please turn to your Exhibit A. 1 is also projected on your screen. As you can see, Ampersand Chowchilla Biomass LLC is in orange. On the other side is Masset Power Plant LLC. Both of these entities is wholly owned by Global Ampersand LLC. These were Global Ampersand was owned up to December 28, 2010 by Ampersand Chowchilla Biomass Fund 1. So,
Do you know what
Right
was the,
there.
excuse me, what was the value in 2010 when it was transferred, the ownership?
our transfer of ownership
What was
value
it?
or their transfer?
No, the assessed value.
The assessed value, we did not know about a change in ownership for 2010. Let me look that up. It's- For 2010, we did have a little change correction, but originally the total value assessed was 15,302,730
In 2010.
in 2010.
And then the subsequent years from 2010 to 2020, how much did it go up in 10 years?
The 20,000, which is, I'm sorry, the subject of the appeal today is 2016 and 17. So for the 2016, originally it was assessed of the total of 7,918,560, and I have processed an escape assessment, which is the subject of this hearing today, and I changed that from $7.9 million to 12,943,750 for 2016. And 2017, it changed from 7,573,580 to 12,960,850.
So from 2010 to 2016, there is no appeal, right, by the applicant. Between 2010 to 2016.
To my knowledge, yes, except for 2009. Yes, that's correct. Yes, the first
Okay.
appeal that I'm aware of was 2019.
So it was all agreed upon and paid until 2016?
I'm not sure. I don't have a record. That would be something that the tax collector's office, but I believe, I cannot say for certain whether or not all these
Okay.
years have been paid.
Thank
That's what's to be something I don't have access to.
So the matter under consideration is from 2017 to current.
No, the subject of this hearing is 2016 and 2017 only.
For only 2 years.
Yes.
Okay. All right, thank you.
I have a valuation question. Did you consider the other two approaches to value?
Well, not for this one because the applicant indicated based totally on the cost basics. But I have not performed a income approach to value for this hearing, no. But for the 2019 hearing, I did, and it's not much change in as far as income and expense for 16, 17, 18, and 19. I would assume if I do perform, it's probably not going to be so far apart from 2019.
Okay, any other
The
questions?
previous report for the 2019 hearing is included in your exhibit packet where Ms. Cooper did perform an income analysis, and I want to talk about what was wrong with that. And if she had done that in the other years, you'd get a similar result.
Okay, we'll come back. Yeah, okay, 1 second. Is there any questions for the assessor office?
If I may overgo through the exhibits again.
Okay, okay. Just hang on, we'll come back to you.
Okay, so the change in ownership took place here. So instead of Ampersand California Chowchilla Biomass LLC owned it, ACM California LLC purchased this entity and become the owner of the two plants, one in Merced County, one in Madera County. On next page, this is the form that I had mentioned, Form 1, BOE 100B, that needs to be submitted to the state, the Board of Equalization, within 90 days. I have highlighted in green also, within 90 days of the change in control or ownership. As it's marked here, it's indicated the change in ownership or control took place in 2010. But the statement was not signed and submitted until on or after 6/29/2020. Please turn to your Exhibit A13. Sorry, I have a person driving for me. Okay, so one more up. So that's A13. This is the application by the applicant. Their opinion of value is $2,580,000. And attached with this application is a letter from Ms. Mandy Jeff Coach. The original attorney filed the application. Okay, so this is the next page of that letter. Actually, this is the letter by Ms. Jeff Coach. The issues at hand is the base year value correction as it's indicated here as a regard. That's the base year value. On the second page, she's indicated that the purchase price is $467,934, and she believes that that should be the starting point or the base year value for this property when we perform the change in ownership. This should be set as the base year value. There's no mentions of any other information as far as methodologies that different need to be reviewed. That was her contention. If you turn to your Exhibit B, this is the United States Court of Federal Claim. This is a court case that had an 11-day trial. This is the decisions from them. I was not given a lot of information surrounding the transfer when I requested through Revenue and Taxation Code Section 441D. Therefore, I have to do my own research, and this is the case. It talk about a lot of how the history of the property and the change in ownership. This is the complete case, the complete decisions writing. It's 35 pages. You don't have to read all that. I have highlighted a lot of them, but this is for your reference if you need to come back to it.
Okay.
Please
I
go.
would object to the admission of this case. It has no precedential value outside of the Court of Claims. To the
Okay.
extent the court made findings of fact, they're not binding on this body.
I would disagree, because in Ms. Jeff Coach's letter, she did mention court cases, environmental issues, and this exact case would mention all that. I was not given information through the 441Ds. This is available to me, and this is mentioned to a lot of the issues that mentioned in Ms. Jeff Coach's letter. I would disagree to have not been entered into evidence.
Again, Ms. Jeffcoat's letter is not part of the appeal. It was a cover letter submitted with additional documentation. She references in terms of historical overview of the environmental problems that shut this plant down. It was shut down by the EPA. It was shut down by San Joaquin Air Quality Control Board. Basically rendered valueless because of the environmental issues. That's what this historical background is about. It doesn't per se pertain to the valuation question before the board.
Well, this is like an example that they have researched, that similar example that they're showing. It's not like are we comparing it with the?
No, I'm not comparing it. I did not receive a lot of information. As I'm going to reference back to the applications on your Exhibit A13. The reason for the appeal, she did not mark anything except for item I. Right here, it says C attached.
Right.
And the attachment is the letter that was written by Ms. Jeff Coach. That's the basics for this appeal. So I would strongly disagree that this case has no relevance and not be entered into evidence.
Okay, at this point, we'll seek legal advice on this, and we'll hold it right now, and we'll answer the objection. Hold on to sir. It's going to be like this. After she is done with her presentation, it will be your turn to do the presentation, and you will be interpreted the same way, like she is being
Absolutely. I just wanted to
interpreted.
again raise the objection,
Yeah,
so it's not.
I'm just
being
letting
waived.
you know that that's the procedure. When you making the presentation, we'll be asking you questions like that. Okay, let's take a 5-minute break and then we'll reconvene. Thank you, Sarah.
Has Ms. Cooper concluded?
Pardon me?
No, she's not.
Oh, okay.
Sorry. Okay.
Sorry, give me a minute, please.
Excuse me, are we ready?
Yeah.
Okay. Okay, Assessment Appeal Board meeting is resumed back after 5 minutes break. And, okay, to answer the objection raised by the applicant, the objection is overruled as reasons given is that it was opened up by the applicant into that issue, and then the assessor office did the research, and it will be allowed.
Thank you,
Let's
sir.
proceed. You're welcome. Let's proceed.
Okay, so that's the court case. As in my narrative presentation section, Revenue and Taxation Code Sections 110 define full cash value or fair market value is whether pay in cash or otherwise. This summary on page C1, Exhibit C1. I have put together a summary from the court case, and any reference on the pages, it would be Exhibit B, page, for example, page 19. So I'm going to just go over that real quick to just give you an example. For example, number one, the principal amount at the time of transfer for the loan that was outstanding was $39,509,999 as of December 15, 2010. And this is referenced back to page 19 of Exhibit B. And I have highlighted that. So if you go back, you will see Exhibit B 19. At the bottom of the page, that's where the loan principal amount comes from. Would you like me to show it on the screen? Okay, thank you. To go back to Exhibit C1, all these cash or cash equivalent is coming from the court case, which I have totaled all those costs, cash or in its equivalent, for the total amount of $74,338,268. And with rounding, the total cash and its equivalent above is virtually the same as the sales price of $74.5 million listed by CalBio and agreed by Mr. Nathaniel Ng as a correct acquisition price. Mr. Ng is a California licensed CPA and the Novogradac manager responsible for the audit of the facility, the Chowchilla and Merced plants. He also further determined that it has an eligible cost of $40,943,280. And that's right there. And it would be on page 22. In this case, I made it easier. So on C2, I made a copy of page 22 and placed it there. And that's was unaudited information by a CPA licensed to practice in California.
Okay.
And then, so remember that $40 million number. From that number is the basics of the cost basic for this plant. And I use that number. And if you turn to your Exhibit D2, okay, in front of you there, it started out at $40,943,280, and if you look to the left of it, and I'm pointing the pointer at it, that's for 2010 acquisition. And when a base year is set, California and Taxation Code Sections 51 allows or requires that it's go up no more than 2%. What over here to the left is the factor of each subsequent years from 2010. So when you go to 2016, I highlighted in yellow. If you come across that 40 million, 0.9 becomes 44,644,999. And the 2017 highlighted in green, and that becomes the base year for 2017. And if you could turn back to D1, the page previous to this page, I have transferred those numbers, the base year value, and it's right here. It said factor base year value for 2016 is that number that we just looked at from calculation. And this is 2017 based on calculation. That's at those numbers. So this the transfer in 2010, this is the base year subsequent to the transfer for 16 and 17.
Could you explain on this page, the one you have right now? You have 16, 17 as, okay, so you're comparing the base value with the cost approach? 44 million versus 34 million?
Well, I will go to detail and that's with you next. Yes, that
Okay.
is using the same $40.9 million set by the CPA
Okay.
who audit the application for the 1603 grant. That same information, put it on a factor table for this type of property, resulted in these numbers, 34,801,790 for 2016, and for 2017 is 32,345,190. Those are the number. If you use that same $40 million and depreciate it for this type of company, that would result to that. And I will show you what it looked like, and it would be on D3.
Okay.
Those numbers come from D3. Right here is the 40,943,280. That's the same thing. I place it at the acquisition year of 2010. This is using the guideline by the State Board of California for this power generating plant using a 25-year life. And from $40 million, put it in this factor, it resulted in 34,801,788. And it's the same for 2017, which is on the next page. But yes, the summary of D1 are those numbers. And let's go back to D1, please. I'm trying to give you a comparisons between different valuations result from the same information. So as you can see, the first column is the factor base year using that cost basic set by the CPA. The second column where it reads industrial life cost approach, right here. That's the one that I just went over with you, using that same cost basic, but factor it to the recommended table by the state. It's resulted in this. And you can see it's lower than the factor base year value, which would have been enrolled. But the enrolled value and the subject of this hearing is 10,980,480 and 11,058,620 for 2016 and 17 respectively. And these numbers are using the reported costs by Ampersand Chowchilla Biomass LLC. And I would show you their reporting. And it started on D7. and it's also projected on your screen. These are the informations reported by the applicant's CPA, Mr. John Moffett, signed by Mr. John Moffett, and I have these right here. The fixture cost is reported by the applicant, and I used that $15 million, and that's the $15 million applied the factor as recommended by the state board, and that's resulted in the $10 million and $11 million as we show on the summary page of D1. Do you
Excuse
have
me.
any question?
Yeah, on this document here, what is this document?
This is the annual request required statement filed by the ampersand Chowchilla Biomass LLC. We send out a statement, or in cases that anything over $100,000, the property
Okay.
owner is required to file a statement with the assessor's office annually. And
So-
this is one of the statement, and the next 2016 and 2017
So
are
this was-
included here.
This was filed in 2016. So that's where the assessor's office takes the information and process the assessment on it.
Yes, that's correct, based on their reported cost, yes.
Okay, okay. All right. What is it? This is what exhibit? D?
D7, it started on page 7. It has multiple pages. The statement has multiple pages, but I'm just showing you the front page where the total cost is. And from that total cost, it's have apply a factor to it, a depreciation to it, and that's what the resulted in the 16 and 17 on the summary page.
Yes, thank you.
You're welcome.
Any other questions?
Um,
Okay, all right, go ahead.
Go ahead.
Oh, sorry. I'm almost done. Okay.
That's what you said 10 minutes ago.
I know, right? On page D25, this is the information I obtained through the last appeal, 2019 appeal. The financial record was provided, and this balance sheet, it shows on page D25. And here, it said under the fixed assets, and I'm pointing to it, Chowchilla Biomass Plant had a cost for assets of $17,819,649.61. So it's what I have arrived at is strictly based on the applicant's application. Exhibit E is just relevant revenue and taxation code. And I would just like to point out to you section 110, where the 5 market and full cash value, just so you know where I read it from. And 110 would be, and it's in number orders. So 110 is exhibit E9. It's defined full cash value, what the purchase price is, whether or not it's paid in real money, in cash or not, or is equivalent. So exhibit E is just strictly tax codes. I just forgot, and I just remember now. I just want to point out one more thing. If you go to your exhibit, A12. Yes. Okay, so this is the property statement submitted for 2011 after the change in ownership. The indicated cost here is $3,833,989, even though they claim that the purchase price was $467,000 and some change. So I just want to point that out. There's many numbers being thrown out there. I think that's conclude my presentation. If you have any question,
Yeah, so what's the bottom line? What value did you come up with, final value?
it would be on your front page of the,
Is that,
12,000,
yes.
12 million?
The total is 12,943,750 for 2016, but the fixture value, which is the subject discussion, is 10,980,480 for 2016. For 2017, the fixture value is 11,058,620. And the personal property is 1,902,230, and for the total of 12,960,850.
okay. Question is, do you ever use, on businesses, do you ever use the approach of income? How much the business is producing as income?
Yes,
Income.
I have. There's three approaches to value: income approach, sale comparable, and cost. And we do typically look at them. As for the last appeal for 2019, I did perform
So
income
out of
approach
those
to
approaches,
value.
which one would you take? Like, you have a cost, you have income, and which one out of those you will take? Would you
Typically,
take
it needs to be reconciled, and when we don't have a lot of information, and the income and expense could vary wildly, the most reliable, and for this type of property, I would believe the cost approach, because it remains constant. The cost doesn't change. It has been established there. The income and expense could vary wildly from year to year. So it's not a very good indicator as far as like a little increase in expense could affect the value greatly. But at the next year, the income like skyrocket. We cannot just go back and say, "Well, you're doing so well last year, we're going to tax you more." So in this case, I would believe the cost approach is more reliable.
What if a business, just hypothetical, if a business is losing income constantly for the last 4 or 5 years, will you consider reducing the assessed value if the business is losing money?
Well, I would rather not answer a hypothetical question without a lot of information to look at. It's pretty
Good.
hard to say. So I'd rather not delve into hypothetical
No,
questions.
is it, okay, let me put it, is assessor common practice to look at businesses' income and adjust the assessed value?
Not on the mass appraisal that we process every year. When there's a concern raised by the property owner, we would request for information to look at that specific assessment.
Okay,
Yes, but we
Thank you.
don't typically look at every year for every property.
thank you. Any other questions on the board?
Yeah, on your exhibit A12, the applicant had wrote building fixture, land and improvements for 3,800,000. And I don't see how did you get the 10 million fixtures?
Oh, just to show you, that's what they reported, but that's not what we use for 2011. We
Oh.
maintain the cost information that had been provided consistently. I don't know why it's changed this year, but that's not what our office used for that year. It's just to show you that they report numbers.
Okay.
We don't know where it came from, actually.
Okay.
I do. It comes from the balance sheet, which is probably a misunderstanding by the CPA. If you look back at Exhibit D25,
Okay, go ahead.
Sorry.
Okay, finish it. Go ahead,
I'm
finish
just
it.
answering the question. If you look back at, Exhibit D25, they've typically reported their balance sheet basis in the factory rather than, there's no link between a book value or tax book value that you'd be shown on a balance sheet and the assessed value of property. They're two distinct concepts. That's a problem when you have a CPA who is not an assessor filling out these forms. I've had this discussion with Mr. Moffett, and hopefully he understands the difference now.
Okay, hold on, we'll come back to
Okay.
that. Okay, let's do, any more questions for Assessor? We can start the other presentation. Okay, so you're done. Then you will be given a chance for rebuttal.
Well,
after that.
I just want to respond to that real quickly. This is a CPA, or was. Mr. Moffett has passed away a few years ago. It's Miss Tammy, I forgot her name.
Yeah, I forgot
But
her
anyway,
name too.
this is a CPA licensed to practice in the state of California. He, I would assume, knows what he's doing. He has been hired by the applicant for many, many years. If it was wrong, it should have been, I don't know. But anyway, he was a CPA licensed to practice in California.
Okay, thank you. Okay, now that concludes your presentation. Now, the applicant will be given chance to do his presentation, and we would like to know why you don't agree with that $12 million whatever assessment the
Well,
assessor office is coming up with, and how you prove otherwise.
well, I don't have the burden of proof today. The county does, so I don't have to prove anything other than her assessment's wrong. In front of
Well,
this
you
board
don't
today.
agree with that, right?
No, I don't agree with that, and I
Okay, so
already
can you
said
tell us
why,
how-
but let me
why-
back up
why
a
you
little
don't-
bit.
Okay,
Before I actually get into my presentation, I want to just rebut a couple things so I don't forget. Ms. Cooper said that Rule 6, or that the cost approach is the most reliable approach here. Absolutely wrong. If you look at Rule 6 of the Board of Equalization, it provides, first of all, that the cost approach is to be used, quote, in conjunction with other value approaches, not on its own, and it's reliable only where a property has relatively little depreciation. You look at her depreciation chart, it was back here, and the way she figured this, it was one of her D exhibits. If you look at her exhibit D, one, and I'll talk about this approach and why this approach in and of itself isn't correct. The industrial life cost approach is simply an age life depreciation calculation. I mean, this property has a significant amount of depreciation. And the Board of Equalization says that the cost approach is really unreliable in these situations. That's why it's to be used in conjunction with other models that may be better indicators of what the value is in a period of time. And before I get into my actual presentation, I also like to note there's a fundamental flaw in Ms. Cooper's where she had it's Exhibit C1, cash and cash equivalent, where she's basically saying there was 39 million in principal value, 17 million in accrued interest. If you look at the court case that she's submitting, and here's the danger of submitting things that aren't necessarily on point. It's Exhibit B at page 19. Okay, it says right there that the Keaton Master Fund paid $350,000 to D.E. Shaw to purchase the debt. Okay, so this was worthless debt. Paid $350,000 to purchase principal loan of almost $40 million and almost $18 million in interest. So to say that's part of the historical cost basis is ridiculous. You don't pay $350,000 for something worth, $57 million. That's why Rule 6, property tax rules of the BOE say that when a property is not new, the acquisition cost can be used as a historical cost basis. So the assessor is starting from the wrong point in her assessment of the historical value of this. I just wanted to make those 2 points before I forgot to mention them. Okay. The Chowchilla Biomass Power Plant was purchased by the appellant on December 28, 2010. And it was structured as a purchase of 100% of the membership interest. So again, we're not disagreeing that a change of ownership occurred. What we're talking about is disagreeing with the determination of value in the escape assessments before the board. At the time of the purchase of the Chowchilla plant, the appellant hired R.W. Beck to conduct an appraisal of the Chowchilla and the Merced facilities, and they determined in 2008, 2 years prior to the purchase, it had a fair market value of $725,000. And that-
Objection, I would not allow, I would object to this being entered into evidence. The appraisal was for the 2008. The transfer was in 2010. It's not applicable to the transfer in question. I would object this into
certainly-
evidence.
Which document we're talking about?
May I respond? It certainly is applicable. This appraisal was the basis that determined the cost that my client paid to purchase the plant. It's absolutely relevant. I'm not saying that's the value. I'm saying that's an indicator of what the value was at the time on or about the purchase in 2010.
2 years prior.
Okay, hold it. Your objection is on which document? Well,
On the exhibit 1, the R.W. Beck appraisal. The appraisal is dated for August 2018. The transfer in question took
08.
place December 28, 2010. It's
okay.
more than 2 years prior to the transfer. So I don't see how this could be entered into evidence.
Does that answer your question?
Evidence is anything that's relevant to this board's determination of what the proper value is. This is certainly relevant to the historical value on or about the time of the purchase.
Which was December 28, 2010.
Right.
Okay. Your objection is sustained. Okay, sir, proceed.
May I have a basis for that sustained objection?
It's already there. Okay. All right. I'm sorry. We'll change it to overruled.
Thank you. The appellant sells the power it generates to PG&E. A copy of its amended agreement is in your binder's Exhibit 2. This power purchase agreement generates the entirety of the appellant's cash flow. This agreement with PG&E expires in 2031 and is currently set at a fixed price. So our client receives a fixed price for each energy unit it sells to PG&E. Inflation-related price increases under the power purchase agreement don't come into effect until 2023, and then they're capped at 60% of inflation. You can see that Exhibit 2, page 3. Therefore, as a result of this inflation cap and the fixed prices until 2023, each year the plant's profitability and value decreases as inflation will continually outpace revenues. Currently, inflation is running at about 4.2%, and I've got the federal calculations at Exhibit 10.1. Notwithstanding that, inflation was projected to run at 2.1% in California in 2021. You can see that Exhibit 10.2. Nonetheless, at a minimum, the plant's losing about 2% in income value and up to 4.2% income value this year. That trend is going to continue. Historically, California has had at least 1.5% inflation for the last decade. The inability of the power sale revenues to keep pace with inflation is a permanent impairment of the plant that was not considered by the assessor, either in terms of the cost approach as to economic obsolescence or in terms of the income approach. And I'll get to both of those in a little bit. Based on the current wholesale prices for biomass energy production, it's unlikely that the purchase contract could be renewed at a price high enough to operate the plant. Depressed wholesale prices due to the availability of less expensive solar and wind power have led to many biomass plant closures. And I've got a couple articles at Exhibit 6 and 7 that talk about biomass is a dying industry in California. They're not making money, just for the reasons I stated. Availability and cheap energy alternatives, solar and wind. A recent offer by Atlantic Power Corporation to purchase the Chowchilla plant for $5 million, which offer assumed that the plant had no value after the expiration of the power purchase agreement with PG&E in 2023, confirms the permanent impairment of this plant. And a copy of that offer letter is attached as Exhibit 11 in your binder. Certainly, if the plant has fixed assets worth $10 million, somebody's not going to buy them for $5 million. Nope. Now, property subject to taxation has to be assessed at its full value, which is defined as its full cash value or fair market value. And as Ms. Cooper already pointed out, that can be found in Revenue and Tax Code Section 110.5 and also in Section 401. Full cash value or fair market value means the amount of cash or its equivalent that the property would bring if exposed to sale in the open market under conditions in which neither the buyer nor seller could take advantage of the exigencies of the other, and both the buyer and seller have knowledge of all the uses and purposes to which the property is adapted and for which it is capable of being used, and of the enforceable restrictions upon those uses and purposes. And that's specifically Revenue and Tax Code Section 110, Subdivision A. Under the California Code of Regulations, Title 18, Section 3, 4, 6, and 8, there are three methods that can be used by the assessor for calculating fair market value: comparative sales or market data approach, the reproduction or replacement cost method, and the income method. All three approaches are to be used by an assessor to arrive as an indication of value. The three indications of value are to be reconciled into one final conclusion of market value, which simply wasn't done here. This is a cost approach based on flawed information with no analysis of what the other two approaches would yield in terms of an assessed value. Ordinarily, determining market value, while not an easy task, is a relatively straightforward process of examining property transactions that take place in the marketplace and inferring value indicators for the properties being appraised from the examined data. However, for some unique properties, like the subject biomass facility, there's a very small market. As such, there's little market data to draw inferences, but you still can use the market approach even with a limited market property. So while the biomass facility is clearly a limited market property, some limited sales data could have been found by the assessor if she would have looked. This limited data should have been analyzed and used in its final reconciliation to determine the assessed value of the plant. If the assessor had even looked at the limited sales data, she would have found several similar facilities, I think the last one was sold in 2018, have been sold for really scrap value. There's no value to these plants. When the PG&E power purchase agreement runs out, they're valueless. Got nothing to do with them. The equipment can't be used for anything else. It's been sold to scrap. Basically, the Chinese government's bought some of the plants for scrap metal purposes. I'm not sure what they're going to do with it. Again, the import of this omission of looking at sales data can be seen again in the offer letter from Atlantic Power attached as Exhibit 11, which offered to purchase the plant for $5 million. Very recent offer. Again, this offer stands in stark contrast to the assessor's value determination in both escape assessments. If our client could receive the amount of money that the county wants to assess in these escape assessments, it'd sell the plant tomorrow.
Can I ask you what kind of raw material they use for production of electricity?
Raw material?
What kind of biomass they use?
They use the dead trees from the orchards.
Right.
Historically, they've done that because of fire danger. Number one, they used to burn the trees in the orchards. They used to, on burn days, they burn them, and then they had the air pollution issue and also the fire danger. So essentially, the biomass plant would go collect these trees, transport them to the facility, chip them, and then burn them for fuel.
Is that what they're doing?
Yes.
But the material is pretty much free, just for the cost of collection. So your raw material is kind of free. I mean, I understand. You have to bring it in and you chip it and then you burn it. But doesn't that bring the cost of production down?
Well, it's not so much the cost of production, it's the lack of stable wholesale prices. The wholesale price has declined for biomass. So even if the cost base is held steady, when the revenues decline, you're damaged.
Aren't you able to sell all this to PG&E?
We can sell the power we produce to PG&E, but again, it's set at a fixed price. But it's not really a fixed price because you have to factor in inflation. Okay, if I get $1 for every tree that I chip, just simple, but inflation's eroding 4.1% of that dollar every year, and I'm still only getting $1 for each unit of electricity I produce, that unit's getting more expensive to produce.
How many employees work at the plant?
I don't know that.
Thank you. Thank you. Proceed.
Yeah, I did know and I don't recall. I don't want to give you wrong information. It's a significant amount. I couldn't tell the exact amount. Why the assessor's replacement cost assessment is incorrect. Board of Equalization Rule 6 authorizes an assessor to use a cost approach that is based on either a reproduction or replacement cost model. Reproduction cost, strictly construed as an estimate of the cost of replacing the subject property with the exact replica using cost of the valuation date. However, this concept of cost is not really useful to an appraiser in most situations, since reproduction cost is irrelevant to establish a property's value if the property could only be replaced by one that's identical in terms of design, materials, and workmanship. But typically what's used is the replacement cost analysis, where the estimated cost to construct a property is that cost equivalent in terms of utility as of the valuation date. This is really a cost concept that's validated by the principle of substitution, because a rational person wouldn't pay any more for a new property, than the cost of the old property. Essentially the theory behind the replacement cost model. Again, Rule 6 provides several guidelines regarding the application and use of the cost approach. Specifically, subdivision A of Rule 6 provides that the cost approach, number one, is to be used in conjunction with other value approaches, is the preferred approach when neither reliable sales data nor income data are available. Here, income data is available. But when the property is not so regulated to make current replacement cost irrelevant to value. And again, it's not appropriate for use with a property that has experienced a lot of depreciation, which this property has. Appraisers analyze three types or causes of depreciation in coming up with a value under the cost approach. There's physical deterioration, functional obsolescence, and external or economic obsolescence. A property can suffer from more than one type of depreciation at any one time. And again, the problem here is the assessor only looked at one type of depreciation, which is physical deterioration. Physical deterioration is a loss in value due to use or the forces of nature. Physical deterioration occurs to virtually all improvements as they age. It lowers their utility and consequently reduces their value. Physical deterioration can be either curable or incurable. Curable physical deterioration is really just repair work, deferred maintenance. Incurable physical deterioration occurs when value added by a repair is less than the cost to cure a defect. Now, in the age-life method of calculating physical deterioration used by the assessor's office, percent depreciation is estimated by dividing the value of the estimated effective age. I think Ms. Cooper said here she used 25 years of the property's total economic life, or here we're talking about the total economic life of the improvements on the land. Depreciation is then converted to dollars by multiplying the percent depreciation by the cost of the improvements, and that's what Ms. Cooper did on her exhibit D1. Here in determining the escape assessment values, the cost approach again was the sole method used in clear contravention of BOE Rule 6. Moreover, the appraiser should have gone beyond the age-life method of calculating depreciation and considered whether functional and/or external obsolescence forms of depreciation are applicable. Functional obsolescence is a property's functional utility and its overall usefulness and desirability. If its overall usefulness declines, it creates a loss in utility and value. And I would argue that that's applicable to the biomass plant, just given the market changes. Probably more applicable, though, is external obsolescence, which is a loss in value caused by negative influences outside of the subject property that are beyond the control of the owner. Unlike physical deterioration and functional obsolescence, which are inherent in the property, external obsolescence is caused by extrinsic and generally marketplace forces. Here again, the property is subject to negative economic influence given the depressed wholesale prices for biomass energy caused by the availability of solar and wind power, much cheaper source of power. Such external obsolescence is generally deemed to be incurable as of the date of valuation. And that's stated in the assessor's handbook. I've attached the excerpt in Exhibit 14. Depreciation resulting from external obsolescence is supposed to be estimated using one of two methods, either the capitalization of net income loss or market comparison. It's generally considered a paired sales analysis. While external obsolescence affects the entire property, a land equipment ratio is used to allocate this obsolescence between the land and the equipment. Here I'd argue the obsolescence would be more attributable to the equipment. So again, the appraiser made two fundamental errors in using the challenge cost approach to valuation. First, she used it alone in contravention of Rule 6, subparagraph A. Secondly, she ignored the external obsolescence caused by extrinsic forces depressing the market for bioenergy production. Again, the obsolescence is shown by the offer to purchase a plant last August for $5 million. Less than half of the escape assessment value that the assessor is trying to make the roll value for the subject years. The assessor also failed to use the income approach. But I want to say that if she had used the income approach, it probably would have been incorrect. I've attached her report from the prior appeal hearing, which I did not take part in, for the 2019 year, and she did attempt in that report to make a comparative income analysis, but she made a fundamental mistake and contravention of the rules laid out by both the Board of Equalization and those contained in the Assessor's Handbook, in particular the Advanced Appraisal Handbook, Section 505, Addendum A, I believe starts at page 178.
I would object to the 2019 enter into evidence. It has no relevance in this hearing.
It absolutely does. The assessor failed to use the income approach. I want to show, even if she had, and she, even if she had, she would have claimed, oh, the values are relatively identical, but by showing how she calculated in the past would certainly be evidence of how she would calculate it if she had calculated it today.
What is your objection?
I would object to to the 2019 hearing information enter into evidence. It's a different year. It has no relevance for the 2016 or 2017 assessment. It's an independent year with its own income and expense. It has no relevance in this case.
He is using as a reference that you have, I don't think you ever use the income approach.
Because it's not one of the issues raised by the applicant. What the application, all these obsolescence or economic obsolescence, external obsolescence is not at issue, is not raised when they apply for this appeal.
Okay, that
That-
doesn't pertain to, she's interrupting my presentation. That doesn't pertain to her objection. Let me address these issues she just raised independently. Anytime an assessment is appealed, okay, the appellant is allowed to challenge the valuation method. It's inherent in the appellate process.
Um,
And again, the 2019 report is relevant only to the extent I want to show that even if the assessor had used the income approach, it was fundamentally flawed and would have showed a much lower value.
I don't think it makes any difference, so, because that income approach was never used anyway.
Well, I think I just like to
Okay.
voice the objection, just for the record.
Okay. Your objection is overruled. Okay, go ahead.
Under the income approach, which was not used in this case, but should have been, value is determined by the duration of income and its risk. Not all investments are subject to the same level of risk, and the result is that not all income streams can be capitalized at the same rate. The income approach seeks to determine the amount an investor would be willing to pay. An investor would be willing to pay for the right to receive the income stream that the property would be expected to yield with the risk attendant to its receipt. So it's not just a naked analysis of income, it's how risky is the income is one of the primary factors. There's other factors. Using the income approach, an appraiser values the income of the property by computing the present worth of the future income stream. And again, this worth depends on the size, shape, duration of the estimated income stream and upon the capitalization rate at which the future income discount is discounted to its present worth. The income method rests upon the assumption that in an open market, a willing buyer of a property would pay a willing seller amount approximately equal to the present value of future income derived from the property. That's why the income approach is generally called the capitalization method, because we're capitalizing or converting an income stream into a capital sum. The key here is that even a small variation in the capitalization rate will result in substantial differences in value. Again, high-risk investments, and I would argue a biomass facility with other facilities closing with stagnating prices is a high-risk investment, and accordingly would carry a higher capitalization rate. Since a property's full value must be determined by reference to a price it would bring in the open market, the net earnings to be capitalized are not those of the present owner of the property, but those that would be anticipated by a prospective purchaser on the other hand. Again, the most recent prospective purchaser of the facility offered $5 million in 2020, Exhibit 11. This gives a good indication of the perceived value of a purchaser of the plant's capitalized earnings. There are two means by which a capitalization rate can be developed. The preferred method is to derive a rate from the market by comparing net incomes that could reasonably have been anticipated from recently sold comparable properties with sales data prices adjusted, if necessary, to cash equivalents. However, in terms of the biomass properties, this wouldn't really work because the ones that have been sold for relatively little other than the scrap value. So alternatively, if the assessor had used the income approach, she would have been required to use what we call the band of investment method, wherein a discount rate is developed by deriving a weighted average of the capitalization rates for both debt and equity capital appropriate to the California money markets. Now, I'm going to talk a little bit about the 2019 analysis that the assessor did. In determining, and this is at Exhibit 13, if you'd like to take a look after the hearing, what the appraiser did was basically took a discount rate out of RERC real estate report from 2019, which is pretty unscientific. It relies on survey responses from subscribers to derive rates of return across broad categories of properties, including a hodgepodge category they call industrial property, which in and of itself is a contravention of the comparable properties requirement when using market data. And there's an example of one of these reports, a more current report, but just for an example, illustrative purposes at Exhibit 12. However, the problem with relying on that report, which the assessor said in her testimony at the last hearing, is what this office does, her office does, is they use these reports to determine cap rates. The problem with that is these reports provide pre-tax yield and pre-tax yields and pre-tax cap rates. Because use of the RERC report would provide a cap rate not in accordance with BOE Rule 8, which requires adjustment of the cap rate to an after-tax cap rate, which the appraiser failed to do when she tried to conduct the income analysis for the 2019 year, and there's an example of her analysis in Exhibit 12. Under the band of investment method, using the weighted average cost of capital approach, the appraiser has to weigh the rates for, again, both debt and equity capital by the respective amounts of such capital she would deem most likely to be employed by prospective purchasers. This method is based on the premise that the yield rate is weighted average return on different portions of the investment, i.e. debt and equity. Now, to calculate the discount rate using this WACC approach, the first step would be to determine the percentage of debt that would be appropriate for the specific property. The percentage remaining after subtracting this debt from 100 is the equity portion. The debt percentage is then multiplied by the cost of the debt, i.e. the mortgage rate, and the equity percentage is multiplied by the expected rate of return for investment. Adding these figures together provides an overall indication of the discount rate. Now, just again for illustrative purposes, there's an example of this weighted average cost of capital method of determining a cap rate in the R.W. Beck appraisal report for the property, which determined, a pre-tax cap rate of 10.34% for the property in 2008. As noted in the Assessor's Handbook, Section 502, Advanced Appraisals, and again, I've got excerpts on Exhibits 14 and 15 of this handbook. The weighted cost of capital is calculated by taking the estimated cost of debt, the estimated cost of equity, combining them and weighing them according to their proportions in the capital structure. But the problem there is the WACC is estimated on after corporate income tax basis. Because interest expense is tax deductible and therefore reduces corporate income tax liability, the cost of debt has to be adjusted to reflect tax savings. The true cost of the debt is its after-tax cost. This is the financing cost that's actually paid. The after-tax cost of debt equals the before-tax interest rate multiplied by the combined federal and state marginal corporate income tax rate, which is the tax rate paid on each incremental dollar of income. Including this adjustment, the WACC is calculated by dividing the after-tax WACC by -1, the combined federal and state corporate income tax calculated as I described earlier. In addition, since the income stream to be capitalized is also before deduction before property taxes, the effective ad valorem property tax rate must also be added to the before tax weighted average cost of capital. There's an example from the Assessor's Handbook, Exhibit 15 of this. Again, this is long, I'm sorry, it's very technical, but it's key because this is how an income approach analysis would have to be done on this property. The formula is RC adjusted, which is weighted average cost of capital adjusted for corporate income taxes and property taxes, equals weighted average cost of capital divided by 1 minus combined state and federal corporate income tax plus the ad valorem property tax rate. So, for example, using the WACC of 10.34% as shown in the R.W. Beck appraisal, using the correct combined state and federal corporate income tax rate of 28% and an ad valorem tax rate of 1%, the adjusted WACC would result in a cap rate of 15.36%. Now, looking at the example of the calculation of net income undertaken by the assessor's office in conjunction with 2019, just being illustrative of why, if she'd use both approaches correctly, the valuation determination here would be much different. Okay. Using the 10% pre-tax cap rate that the assessor applied in her income approach in conjunction with 2019, using a corrected combined state and federal income tax rate of 28% and ad valorem property tax rate of 1%, the adjusted WACC would result in a cap rate of 14.88%. Now, if you take that adjusted cap rate of 14.88% and the net income as determined by the assessor for 2019 of $1,837,750, that's referenced in Exhibit 9, would result in a valuation for this property in 2019 of $7,951,202, which is basically on point with the reduced assessment from the previous year. So again, the fatal flaw here in the escape assessments is not even considering a correct valuation under the income approach and wholly ignoring the market data out there that would show these plants are basically scrap value at the time their power purchase agreements expire. With that, I conclude.
Okay, questions? Do you, what would you say about this exhibit D7, assessors exhibit D7?
Again, I would say that what happened here that's why there's been different numbers. There's been some confusion. Is essentially at the time the plant, I won't say the plant was purchased, at the time our client acquired the plant through its membership interest purchase, it just continued carrying on the historical cost basis that the plant had shown on these reports prior to that year, when in actuality what should have probably been done, if I'd have been consulted, was to change it to the acquisition cost that had been paid, not the historical cost basis.
So you are you saying that this is an error?
I'm saying it's a
mistake?
book figure
Okay.
that should not be attributed or associated with the acquisition cost that our client paid for the property.
But the assessor office will assume that this is what you are saying, the property
Right,
value
but the
is,
assess-
they will do the tax on that.
Correct. That's why Ms. Jeffcoat, the previous counsel for our client, informed her that that was incorrect and that she should have looked at the acquisition cost rather than historical costs for these years.
Did they ever correct it?
I mean, in terms of reporting,
Right.
I don't believe I'm not sure they can correct it for the 2011 report.
Was it ever corrected since, until now?
I can't answer that. I only have the information in front of me, and I've only been associated with
I understand.
with these 2 years, and I have a little bit of familiarity with the 2019.
That's all right. I understand. Any other question?
Yeah. The assessors have access to all your income approaches during those years, 2016 and
Yes, we report income. We basically report income. I mean, not income in terms of income, but revenues. It's better word. We report
Yeah.
revenues, report expenses. What the assessor then does is back out certain things, paper expenses like depreciation, comes up with a net operating income, and then again, divided it by this adjusted WACC, which would give you another value that you would then have to reconcile. I mean, even if she'd done the cost approach correctly, which she didn't do, certainly using the income approach would have provided a much lower number, which would have lowered the results of the assessment.
Okay, so if you would have to assess the value today, what would you do? How much would you come up?
Again, I don't have the burden of proof here. What I would like to see is, I could certainly come back with that information. We could do it ourselves independently, but you need to conduct a correct historical cost analysis with a correct depreciation analysis. You'd have to look at market sales data, and you'd have to do an income approach analysis and reconcile all three. I mean, that's, for my client to do that would be tens of thousands of dollars. And again, it's not our burden here today under the escape assessments. I mean, I'm showing you that these assessments, first of all, were done in contravention of Rule 6, and they did not consider all approaches.
Okay, this is the additional assessment, like what do we call them?
Escape assessment, sir.
Escape assessment. Okay, so you are saying that it should be zero. There should be
Yes.
no escape.
Yes, the
Okay,
assessments have
that's
already been
true.
made and paid. These are trying to get monies from the past that
Right.
simply are based on an erroneous valuation.
So you're saying it should be totally removed and original value, whatever that was, should be retained.
That is absolutely correct.
Okay, that's your stand.
Yes, it is.
Thank you. Thank you. Okay, so if there are no questions for the applicant, then we'll go back to assessor for rebuttal.
Yes, I have a few things that I would like to mention.
Sure.
Please go back to Exhibit 7. It's actually, I would renew my objection because this is not what was presented in the actual hearing for the 2019. This information was in exchange when we were discussing how we can come up with an agreement. This was in exchange with the CPA and the applicant at the time. This was not what actually presented in hearing. And I look back at my presentation for the 2019, it would have been Exhibit B of the 2019 hearing. And the date of that hearing is March 5th, 2020. The appeal number is 19R006. Applicant Exhibit 7 today is not the same as Exhibit B, the discounted cash flow for that hearing. I just like to renew my objection for that.
Do you have the one that they submitted at that time? And
I have a copy on my
2019.
file, but Ms. Anderson would have an official record of that.
so you're saying one they showing here is not the relevant one?
It's not what was presented
Can
at
I-
the hearing.
Can I interject?
Yes, sir.
It might not be the actual worksheet, but that's absolutely what she testified to. You can read her testimony. I've attached it as an exhibit. She gave that exact valuation that's shown on the exhibit I provided, and she used a 10% cap rate, which was an error. So whether or not that's the exhibit, she testified to it during the hearing under penalty of perjury.
But do you agree that this document, one you have here, shown as 7, Exhibit 7, was this the exact same document that was presented in 2019?
I can't answer that. I didn't do that hearing, but again, I can tell you that her testimony matches that document on all fours.
Okay, thank you. Okay. All right.
Could go to my rebuttal,
Go
to
back.
the presentation. There's a few things that the applicant has raised, such as obsolescent issues. That's not what the applications indicated. Application indicated that we didn't use the purchase price of $467,934. The stated opinion of value for the 2016 and 2017 is $2,580,000. I don't agree with the applicant's indication that he has no burden of proof. He does. He has to prove that the plan had a market value of $2,580,000 for 2016 and 17. Yes, he does. Obsolescence never was raised in the application. And actually, he has not presented anything as to value.
Because it's not my burden here today. This is an escape assessment. She is increasing, whenever the assessor's office seeks to increase the roll value, already recorded roll value, the burden is on the assessor's office. Case law. She's wrong.
Thank you. I haven't seen any value on the real estate. Do they own the real estate too?
No, this is on leased land, sir.
That's a lease land. Okay. Thank you. Okay, go ahead. Are you finished with your rebuttal or you still have more?
I think I really don't have any question because he has not presented anything in regard to value, so I do really don't have any question for the applicant. I think if we don't have any, if we don't have anything, probably closing statement, but then I have the last and closing statement.
Yes, I understand. Okay, any question? Okay.
How long is your closing?
Minute?
Okay, go ahead with your closing statement, sir.
Again, because this is the assessor seeking to increase the amount of the assessment already reported on the roll, the assessor's office has the burden of proof. The assessor can't meet that burden because she conducted this valuation in violation of Rule 6 of the BOE that says that the costing method cannot be used alone. It must be used in conjunction with other methods. Also points out that this method is flawed in the context of a heavily depreciated property, which we have here, which is why these assessments fail for their lack of consideration of the other approaches, which would have significantly lowered the value. Thank you.
Thank you very much. We appreciate your presentation and we'll let you know. how
Thank you
it's
very
taken.
much. I appreciate the time and the questions and the air conditioning.
Thank you. Okay, assessor's office,
Yes, in my closing.
yes, closing statement, please.
Okay, give me a minute to pull something up, please. Sarah, could you? Sorry.
You can have a seat, sir.
Okay, thank you.
Thank you.
Didn't want to distract you, just.
The applicant stated, quote, unquote, purchase price was $467,934. Cost reported for the 2011 from the power plant property statement is $3,833,989. The applicant's opinion of value on the assessment appeal application is $2,580,000. The audited sales price by an independent CPA and accounting firm is $74.5 million for both the Madera and Merced plants. And the cost basic determined by this same CPA and accounting firm is $40,943,280. Those two are the only number that have been audited and reviewed by a licensed CPA. In my closing, the applicant have shown a few numbers as far as values concerned for your consideration. I believe the applicant has not proved, actually, I was going to say preponderance of evidence. Actually, he did not even show how the market value could be $2.58 million as stated on the application. So he, instead of saying with preponderance of evidence of the purchase price, he has not proved anything. On the contrary, the applicant's accountant, Mr. Nathaniel Ng, a certified public accountant, licensed to practice in California, and the manager of Nova Radak and Company LLC, a public accounting firm responsible for the facilities audited and agree that the purchase price of $7.4 million is correct, and determine that the Chowchilla plan has an eligible cost basic of $40,943,280. The assessors revalue the trade fixture based on the eligible cost basic and as indicated by the applicant CPA in the United States Court of Federal Claims. As I demonstrated in Exhibit D, the factor base year value for 2016 and 2017 were much higher than the enrolled value of $10,980,480 and $11,058,620 respectively for the trade fixture value. The enrolled value are the results from using the reported by Ampersand Chowchilla Biomass LLC, the wholly legal entity owned by ACM California LLC. Ampersand is the entity that filed the statement and claim depreciation for equipment owned, not ACM California LLC. The value change and the enrolled value by the assessor are supported by Ampersand's own financial records. No issues was ever raised in obsolescence. I could, just like the applicant have indicated, perform and submit the income approach to value if he does the same. So I respectfully request that the board accept the value as shown on the cover page of the presentation as presented today. I thank you for your time and consideration.
Thank you. Thank you very much. Okay, so this concludes the hearing on ampersand item number 5E6828. And we will take the matter to consideration and make a decision later on. Thank you. Thank you very much. Shall we go ahead and just finish item 5C and 5B, then start the hearing?
How long is it?
Yeah, I need
Yeah,
that.
So you representing Golfshan?
Yes, I am Sasan Golofshan.
How long is going to be for your?
Fairly quick,
Is it quick?
fairly quick.
Okay, shall we start with that then?
I'm fine.
I have an appointment at 11:30.
7:30? Okay, let's.
It'll be
do this.
quick.
Yeah, okay, sir, introduce, okay.
Okay, good.
All right, so this is a regular assessment or the burden of proof is on the applicant, right? So they should go first,
Correct, this is a regular assessment.
regular assessment, okay.
He needs to be sworn.
Yes, he was a sworn in, so Sarah,
First, you'll find a oath of office form, blank form, or is there one up there?
No, nothing here.
Hold on just a moment.
can we go ahead and do the other two items? The ones are withdrawn, 5B and 5C. We make a motion and 5B. Can we go ahead and do that?
You lawyer. No, those-
Yeah, just make a motion and withdraw them. So they're out of there.
Pay that assessment, might as well take the pen.
Do you solemnly swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Thank you.
State your full name.
Good morning, my name is Sasan Golofshan. I am the founder and owner of Form Fitness. One of our locations is in Oakhurst, California, which is in Madera County,
And your county of residence?
Santa Clara County.
Thank you. Okay, sir, go ahead.
Basically, after much consideration, first of all, I want to thank staff for doing an amazing job working with me. Brian has been incredible, very empathetic, sympathetic to what we've had to deal with. But long and short of it is that the numbers and the calculations, there's no dispute there. I guess the angle that I would like to take and the request that I have of the board is that I built this space. My in-laws are 4 generations core school residents. My children visit core school Oakhurst on a regular basis. That's where grandma and the cousins are. So when I built this gym, it was really about a gift for the community that didn't have anything, especially up there. We've done a great job. We've run a good business. We employ a good number of people. We are the source of health, especially at a time of COVID, which is a good reminder. We've always paid our bills. We've never disputed anything. But I must say that today I struggle deeply with the assessment that's before us, not because I don't trust Brian and his calculation. He's been amazing, but because of the fact that we were shut down for no fault of our own. And I understand that 2020 assessment occurs in January. But what I would like to ask the board to consider is to just prorate our tax for 2020. I am more than happy to pay our fair share before we were shut down. But once we were shut down, there's no way for me to be able to pay my duties to the county. And I'm not an attorney, but my understanding is that there's a concept called frustration of purpose, which means that if we agree to get into a contract, but then you prohibit me from conducting my duties through the contract, you can't then ask me to pay or give my portion. So I would like for the board to seriously consider my request on those grounds, but more importantly, the fact that if we do have to pay this, there's no way that we can justify staying there. And once we're out of that building will remain empty for another 10 years. It used to be Gottschalk's. It was empty for 5, and it was horrible. I didn't like seeing it, even though I don't live there permanently. So what I'd like to propose is for the board to consider my request to prorate our tax assessment for the 2020 year to only be the amount that we were open. Obviously, that affects 2021 and 2022 because, again, even though we're open, limited, as you can imagine, it's been very tough on brick and mortar.
Well, we understand and we sympathize with you because of the COVID. A lot of businesses have suffered. I'm a businessman too.
Yes.
Quite well understand what you're saying. It's very unfortunate we are going through that. And there is some federal help available to that. I'm sure you're aware of that. And I wonder if you avail that, the federal grant help and PPP programs that are available.
We applied for all of them. But
Right.
unfortunately, unlike the restaurant business, as a gym owner, I simply became unemployment office for 2 months. I had to pay my staff, my employees, all the money that was given to us, and we were not open. So unlike restaurants where they were open, they could do takeout, they could generate some sort of revenue, our hands were tied. We couldn't do anything. So essentially, we became unemployment office for 2 months. Soon as the PPP was spent, we got the audit, the loan was forgiven, but all those funds went to the employees. I actually don't collect the paycheck from Oakhurst
I
facility.
understand. So what you're asking is You agree with the assessment, which is 1.2 million?
Actually, Brian and I have spoken since, and we provided more information, and Brian has a new assessment, which I agree with.
Okay,
I agree with that assessment. I simply just ask that you prorate that instead of a 12-month cycle, or it to be until March, where we were ordered to shut down, which we did.
okay, thank you. Will have any questions?
But
Yeah,
that's
for
beyond
Brian.
this.
Yeah.
Well, we just look at the values.
Right, so we'll have an assessor's office say what they want to say. It's your turn.
Thank you. Brian Glover, Deputy Assessor of Real Property with the Madera County Assessor's Office. As Sasan stated, the assessment was originally started in 2015 when the business opened, and it is factored up by no more than 2% annually from there. That assessment was based on a business property statement reporting. It was just a gross number for structures and improvements. When Mr. Hassan reached out to us early last year, in talking with them, it became apparent that there may be some cost in that number that aren't necessarily associated directly with the building. So I went through the detailed report that his accountant provided, and we would recommend reducing the structure value down to $926,000 for the 2020 tax year in question. The real question and the issue that we have here is that California property tax law dictates January 1st as being the effective date for our valuations. And unfortunately, when they wrote it, when they wrote Prop 13, they didn't anticipate a global pandemic would come 3 months after the lien date. Theoretically, the state legislature or the governor could have adjusted that date that we have to use, but they have chosen not to. Our hands, unfortunately, based on the law, are tied. We have to value the property as of January 1st each year. That being said, we can reflect the decrease, in the coming tax bill, and then we will. I'll work with on that. But our hands are somewhat tied in adjusting due to events that happened 3 months after our lien date.
So you can't do the proration like the applicant is asking?
No, this doesn't qualify as a disaster in that like we had the Creek Fire this year. The properties that were physically destroyed in that, we can prorate, but the building is still physically there. The R&T code that discusses calamities states physical damage. It's a quirk in the law that says we have to value everything as of January 1st. So on January 1st, 2020, nobody had heard of COVID. Nobody knew, what the next year was going to be. January 1st, 2021, which is the role we're preparing now, and the bill that he will receive this fall is going to look dramatically different. Because as of January 1st, 2021, we were very aware of what COVID has done to.
Any question for assessors? No. Okay, sir, how would you like to say rebuttal?
Again, I thank the assessor, I thank the board, because this has not been a good year for anyone, and I don't envy the position everyone's in. But I will say that even though I respect all laws, and I'm a law-abiding citizen personally and also in business, just as I have been told of COVID being an exception in many ways, just as I've been told you have to shut down regardless, I would just ask the board to take my proposal to consideration, because you have the power. Even though perhaps the law in the books may be different, it appears that COVID pretty much made every law and every book pretty much irrelevant. And so I simply ask you, mainly because it's not so much about me preserving that gym, but if we're not able to stay open because of the bill that's upon me today, it's going to reflect poorly in the county. And to be honest, that money stays here. The property tax that I pay, I know where it goes. It goes to good use, to education, services, and so forth of a county that's very much in need of it. So if anything, I consider your decision in our favor as a way of investing in many more years of the gym being here for the county and the community up in the mountains.
Thank you very much. Thank you. Any closing statement or you already
No,
done?
I would reiterate that I feel force us on, but on the pure reading of the law, our hands are tied in this.
Thank you. Thank you very much, sir.
Thank you so
We'll let
much.
you know our decision shortly.
Thank you.
Shortly means it will probably be mailed to you.
Okay.
Okay, thank you.
Thank you very much.
Thank you. Yes, we can. We take a 5 minutes break or 10.
Going to lunch.
Okay.
Gotta go to lunch. We come back, I could.
Okay.
12:30?
Reconvene at 12:30. Okay. Madera County Assessment Appeals Board meeting is called back to order after lunch break. It's about 12:40 p.m., June 3rd, 2021. And I think we should go ahead and discuss the 2 hearings that we had, and we take that matter into consideration and discuss that in the conference room. So we go on break and we'll reconvene.
Chair, I was going to ask if we could go ahead and take up the Old Castle and the CTI so the assessor's office could go ahead and leave while we.
Exactly,
that's a
I'm
good
sorry.
Sorry about that.
Sorry, we reconvene. Okay, let's take the matter 5B, 6983, hearing for Old Castle Precast Incorporated 20R015. And the other one is the same, or no, they're 2 different ones. Okay, this one, I understand the applicant or the applicant has withdrawn. Is that true?
Yes, sir, and Ms. Anderson has both withdrawn.
I provided them to you this morning with your packet.
Okay. All right, so let's have a motion on that.
I move that we accept the withdrawal of the Old Castle Precast Inc. 20R015.
I second.
There's a motion and there's a second. All in favor, say aye.
Aye.
Motion passes. Next item is 5C. 7113, hearing for CTI Towers SS LLC 20R025, and I understand the applicant has withdrawn. Assessor's office, any comments?
No comments, sir.
Okay. So do we
I
have a
so
motion?
move that we accept it.
Okay, we have a motion. We have a second. All in favor, say aye. Aye. Motion passes. So we don't have
Done
any
with the
other.
hearings?
So the
We could
only-
do the non-hearing staff reports and adjournment, or
Yeah.
minus the adjournment.
Let's say if it pleases the
Okay.
board, we could give the staff report before you go to deliberate.
Yes, please, go ahead.
Just kind of recap of where we're at. Next month should finish up our scheduled appeal hearings. We have had 4 on the schedule, but I see we just received a withdrawal for 1.
Yay.
Okay,
So
all right,
likely two hearings to come out of next month.
okay. And we are meeting the first Thursday again?
Yes,
Or
in
is there any
July.
change? Okay. All right. July, what is that day? July
July 1st.
4th?
First.
First.
We don't want to meet on July 4th.
It's gonna be 4th of July.
We can celebrate here.
All that leaves after those 4 will be our Canandaigua and Constellation brands. We'll provide you an update next month, at next month's hearing on those.
What's the status on Constellation?
We'll provide you a status report next month, sir.
They still
that.
want to have a hearing or no?
Joe's gonna update
Yes.
us.
They'll
Okay.
update us.
Okay.
Yeah.
All right, so it's next meeting
Given
is,
given the schedule, we would like to move to cancel August and September's. You know, we have
Really?
nothing on the schedule.
you guys going on a vacation or what?
No, but we don't have anything to present to you, so we'll let you guys go on a vacation.
I'm good.
Okay.
We
All
would
right.
request to keep October, November, and December open.
Wish we could travel.
Right.
You can if you want.
Yeah. You
In-
can
in
wear
case
mask
we,
over the entire flight.
The nice thing about it, if we cancel it now, if we have any hearings in July that need to be continued, we won't calendar them for those months, but it still gives us October, November, and December to reschedule to.
Right. We would like to hold those hearing dates open,
Okay.
potentially for Canandaigua.
So do we have to make a motion to,
Yes, ma'am.
oh, okay. Before we go there, can we talk a little bit about our other member? Did we ever get another member?
Yes. So my staff report is we have Beth Carver. She was going to join us today, but she had a prior holiday adventure scheduled, so she will be sitting in, I guess, in our October meeting to introduce herself to y'all and get a feel on how we do. So
You won't be here for our next meeting on?
for the July, oh, I'm sorry, she might be here for July. I didn't ask.
Okay. Curious.
All right, then,
I make a motion
I second it.
to
All right.
cancel our meetings on August and September?
August and September, correct?
August and September.
I
Okay.
second that.
okay, we have a motion and we have a second. All in favor, say aye.
Aye.
The motion passes. Okay, now, I guess assessor office is all done. You are excused. And we will do the rest of the process. Okay, we will take a recess and we'll reconvene.
Thank you. Thank
Thank you,
you.
thank you very much.
Okay. Okay.
Now you're planning retirement again? Okay. I would have started thinking about retirement. I think I would rather retire.
No,
Well,
I mean,
the
you know,
job is good, only
Exactly.
a couple of hours a day. Okay. Madera County Assessment Appeals Board meeting is called back to order after short recess. It is 2:50 PM, April 3rd, 2021.
150.
Sorry, the correction on the time is 1:52, April 3rd, 2021. And we have reconvened and we had a discussion on the ampersand item number 20R001. And what is that we would like to do?
Just to clarify, the appeal number is 20S002 and 20S003.
Okay, we stand corrected on that. Okay, gentlemen, what we like to do? How we want to proceed? It's on. We did have a discussion, closed meeting. Item number 6827 and 6828 were considered. And gentlemen, like to make a motion on that?
Okay. I move that we continue the deliberation until July 1st. July 1st.
Okay, we have a motion. We have a second.
I second.
We have a motion. We have a second. All in favor say aye.
Aye.
Aye. Motion passes.
July 1st.
Yes, July 1st. July
We'll
1st,
have-
I amend that.
Continue this discussion on July 1st as per the motion. Okay, we have done everything else. Staff reports.
Yes, we still have 5A,
Okay, 5A.
which is appeal number 20R001.
Yes, we did that. We had a closed meeting on item 7049 on Gulfshan. And gentlemen, anybody likes to make a motion on that?
Move that we go with the assessment, the assessor's office with the value that they have.
Okay, so we agree with the assessor's office. Okay, now we have a motion. Do we have a second? Okay, we have a motion. We have a second. All in favor say aye. Aye. Motion passes. Okay, I guess, is there anything else? Staff report or anything? Sarah, nothing? Okay. I guess we're ready to adjourn. We can entertain a motion.
I second.
All in favor say aye.
Aye.
Meeting adjourned. Thank you very much. Here's, are we planning to go now?